Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a case out of Alberta involving three men who have opposed COVID restrictions in quite extreme fashion and new court orders against them. Pastor Artur Pawlowski of Street Church Ministries, his brother, Dawid Pawlowski, and cafe owner Chris Scott were all sentenced recently for contempt of court convictions. Alberta Health Services had obtained court orders to help them enforce gathering limits, which their church had continued to violate. The men then violated those court orders designed to stop the services, and the men were arrested in dramatic fashion. Now, these men have made the brothers in particular, have made some extreme and indeed offensive statements about the pandemic. And I don't want to gloss over those statements or the fact that violating a court order will and should lead to consequences. But what struck many people as strange about this case was that the court-ordered consequences included not just large fines, but a term of probation that requires them to include the other side of the argument in any of their expressions opposing public health orders. This included a very specific statement about the majority of medical experts favoring social distancing, masking, and vaccination. Here today to talk about the case is Mr. Pawlowski's lawyer, Sarah Miller. We'll then be joined by a panel of legal experts to discuss the case. Ms. Miller, thank you so much for joining me. Now I have to say, starting off, I really disagree with a lot of what your client has said. So I'm not completely neutral, but I am definitely concerned about the courts ordering someone to say a specific thing. To me, that seems too far. So I want to get your reaction to that term in the probation order for Mr. Pawlowski.
Yeah, I mean, many people disagree with some of the things that Artur or David say in the public or what they promote. That wasn't really part of either the order of Justice Rook. Justice Rook was trying to prohibit gatherings that were not the church, that were associated to Christopher Scott in central Alberta. Alberta Health Services then enforces this order against the Pawlowskis without giving them notice. It's an overreach at first instance, and then we get this order from Justice Germain indicating that they must say certain things, which is, in my estimation, definitely a violation of their Section 2 rights.
Now, how unusual is it to see a term like this, an order to say a specific thing as a term in a probation order?
Well, I think the last time a judge or an arbitrator made a decision like this is in something like the 80s. It's not common, it's not usual, and the Supreme Court of Canada has said it's unconstitutional. So I think that usually criminal probation orders turn their minds to whether or not an order is constitutional or not. Unfortunately, with the current public health situation and pandemic, I think it's taken away some of that focus on what's fair or the normal sentencing principles, and has really turned this on to a focus on fake news and Facebook science and things like that to try and suppress that, which of course in theory is absolutely commendable, right? We don't want fake news around on Facebook and fake science to be spread, but to have a court order what you can and cannot say, or what you need to say every time you open your mouth in public, is quite an overreach.
I think they're allowed to say the things that they're saying, which are some sort of conspiratorial ideas about COVID. But the issue is that they've been required to say another certain thing, a thing that they don't believe, which is interesting to me. And I'm curious where you are procedurally if you're challenging that part of the order.
Yeah, we've filed a notice of appeal for the order. For the Pawlowskis, I can't speak to Mr. Scott's strategy or his case, but for the Pawlowskis, we've had really an issue with even the finding of contempt. I realize that's not really the point of this segment, but we filed a notice of appeal for that. Now we filed a notice of appeal for the sanction itself. We've also filed an application with the Court of Appeal here in Alberta to say, whoa, this sanction is so unreasonable that you need to stay this pending the appeal. It raises some really important legal issues.
When we come back from this commercial break, I want to talk more about what else was included in this sanction order. We'll be right back. Welcome back to Canadian Justice, where we're chatting with the lawyer of an Alberta man and pastor who was sanctioned for violating court orders related to public health, and that part of that sanction includes some compelled speech. Now, Ms. Miller, this decision, there were two decisions about these sanctions that compel some speech. One was for the brothers Pavlovsky, and the other was for a man, Chris Scott. And these cases are actually very similar, but actually unrelated to one another. What can you tell me about the difference here?
So Christopher Scott is related to the anti-lockdown rodeo that was in Alberta this past spring. I don't know the exact details of that. I'm not his counsel. I wasn't following that kind of gathering. That was hours away from where I live. So where the Pavlovskys run Street Church, they've done this in Calgary for nearly or over 20 years, I guess, for Arthur, and nearly 20 years for David. They're totally separate groups. The Pavlovskys have become the subject of Rook's order by virtue of the actions of CPS and Alberta Health Services. But Justice Rook actually issued the order in response to the anti-lockdown rodeo and other events that were happening in central Alberta, so many hours from Calgary, where we live. It was that order that then, although was designed or appears on its face to be designed to just target Christopher Scott, his associate Glenn Carrott, the Whistle Stop, where they host their gatherings and people acting under their instructions or in concert with them or independently to like effect. That was the language in the order. Calgary Police Service then took that order and tried to effectively enforce it against the Pavlovskys, Alberta Health Services, and filed an application to find the Pavlovskys in contempt. So these are separate groups under contempt of the same order, and for similar reasons, gathering in excess of the gathering restrictions.
And in all three of them, although there were two separate decisions and the cases are unrelated, they all have the same part of this sanction, which includes this, what I would call compelled speech. And is there existing law in Canada about whether a court or government can compel certain speech? Because my understanding, there's not a whole ton of case law on this topic.
No, there's a case, and I can't remember the name of it, but it's a union case, and the labor arbitrator or some decision maker had ordered the employer to make certain statements regarding unionized environments, those types of things, and that was ordered or found to be unconstitutional. So there are a few cases, kind of sporadically this comes up. A judge or an arbitrator makes these kinds of rulings where this is how we're going to fix this problem. We're going to order you to say a certain thing. It more often comes up in marketing and advertising. We've seen it in cigarettes and advertising of that sort of nature. It's not often so individualized and so specific as to say, well, if you open your mouth to say one thing, you then have to caveat it with what the majority point of view is, or the view that the judge sees as right.
Now, another thing that stood out to me in this decision was that the judge wrote that Pastor Pavlovsky is, to use his word, entitled to express his views about the government, the courts, and Alberta public health, but he must do it in a respectful, hate-free way that doesn't breach the orders. Now, this is really odd to me. There's no obligation that anyone express themselves respectfully. So if that were the case, a lot of people I see on Twitter would be in a lot of trouble. So what is that part of the judgment about?
Well, Christine, that was the part that struck me as the most bizarre as well, because there's really very little that the Pavlovskys have said that, is necessarily respectful of Alberta Health Services, but there's no law about that whatsoever. And there's also no order. Justice Rook's order was about, can you gather in groups in over 10 or over 15 or whatever the public health order decides at the time? has nothing to do with what you're permitted to say. And so this whole segue into, oh, well, you can only express yourself if it's not hateful and it's respectful and all of that. Well, there's rules and laws regarding hate speech. I don't think that the Pawlowskis have necessarily made it there, but it's not part of this contempt proceeding at all. So it was completely bizarre to me. And then to make the order not about what they had done, which is about gathering, but to turn it on its head and go, well, this is going to be now about your speech. And there's really no evidence in the proceedings about what the Pawlowskis say. So it was very disconnected, it seemed to me.
That's all the time we have, Sarah, but thank you for joining me and good luck in your case.
Thank you so much, Christine.
Welcome back to Canadian Justice, where we're discussing sanctions against Alberta men who were charged with contempt for violating a court order. We are joined now by legal experts Mark Mancini and Chris Kinsinger. Thank you both so much for joining me today. Mark, as part of that probation order, these men were given a requirement to say certain things if they're expressing their right to freedom of expression. What's your take on that as part of the probation order? Is this compelled speech? Is this normal? What's your reaction?
Oh, thank you, Christine, and thanks for having us on to talk about this. My view is that this sort of tag at the end of the probation order, and especially the inclusion of a suggested script for the brothers to say, is certainly compelled speech. It's one thing to levy fines and a contempt of order finding against them, and I think that was perfectly supportable on the record and based on their activities. It's another thing altogether to tell them or even suggest that they have to say certain things to meet the terms of that order. And so for even if it's true, even if it's science, even if it's consensus established facts, that it's still compelled speech. And I think we have to ask really clearly here, did the court go too far in putting this script into its probation order?
Chris, same question to you. What's your take on that part of the probation order, the compelled speech part?
Thanks again for having me back on, Christine. I completely agree with Mark that this amounts to compelled expression. And I think it's especially discouraging to seeing it coming out of a court decision in a probation order. Such an order has no place in a country like ours, where our Constitution enshrines freedom of expression as a fundamental freedom and as one of the most important guarantees that we have. So even though courts themselves cannot violate the Charter, courts are only legislatures and executive actors are subject to the Charter. I think this is inconsistent with the spirit of our Constitution.
Now, Mark, one thing that's interesting to me is that I kind of understand in part where the judge is coming from here. He didn't want to give Mr. Pawlowski a prison term. He actually wrote that Pastor Pawlowski had a fervent desire to be martyred by a prison term. So I understand the judge not wanting to give it to him and to do something else instead. And I guess this is what he came up with. But I mean, the fine is one thing, but what would have been a different alternative if prison wasn't what the judge wanted to do here?
Yeah, we addressed it. But Leonid Sirota and I, in our blog post on this matter on Double Ask, we addressed this. And Leonid does a lot of work in compelled speech and addresses this issue. The problem here in this decision is that a lot of the judge's comments, and especially on the whole martyrdom piece, really sounds in a personal disdain for the brothers. And I certainly understand that. I certainly understand the frustration. The anti-vax movement, I think, has done a lot of harm in this country. But this is where freedom of speech is particularly important when it's when it's used to protect people whose views might be unpopular. And as Chris said, while the court isn't the Charter doesn't necessarily apply to courts, we don't see in this decision any sort of wrestling with any other alternatives to this sort of order. We don't see any wrestling with the doctrine or the rules governing freedom of expression. And it's also for that reason that I think the decision is really flawed. The reasoning isn't there to support such a bizarre remedy of ordering a script for the brothers to say.
Now, Chris, the judge did seem angry in this decision, exactly as Mark described it. He wrote about how the pastor shouldn't compare public health officials to Nazis. I mean, I agree. He scolded him for criticizing Canada abroad. I also think that that's not a great thing to do. But I don't really understand the role of those comments in the judgment. What's your take on that?
I think once again, Christine, I'm going to be in agreement with Mark here that certainly these sort of comments are very discouraging. And we've seen a lot of polarization these past 20 months. We've seen a lot of misinformation, and we've seen a lot of vitriol that's being thrown about with regard to the pandemic. But as Mark said, I don't think the solution here is to attack the content of that sort of expression directly. The bar for actually prohibiting certain types of expression has to be very high. It has to result in some sort of empirical harm. And as offensive and even potentially dangerous as this sort of expression is, I'm not convinced that it meets that bar. And so I think the solution here is for better public health communication.
When we come back from this commercial break, we're going to expand on that a little more. Welcome back to Canadian Justice, where we're chatting about an Alberta pastor who's been sanctioned for violating court orders related to public health, including a part of that sanction that includes compelled speech. Now, this case involved a pastor. And Chris, you have recently written in the National Post a column about why the anti-vaccine and anti-public health sentiment isn't somehow inherently Christian. And it's interesting to me that some of the vocal opposition to public health measures does come from, in part at least, a certain segment of Christian groups. So can you explain the argument you made in the National Post? Because I certainly agree there's nothing inherent in the faith that should be pushing it for an anti-vaccine sentiment. But what do you mean by that?
Thanks, Christine. And I think I just say at the outset that certainly there is a vocal minority within the Christian community that is opposed to the vaccines, but they are a minority. Not just among conservative Christians, though, or all Christians rather, but even amongst conservative, theologically conservative Christians. This is a relatively small but very vocal group. Essentially, the argument that I made in this editorial with my colleague, Brian Bird, who's a law professor at the University of British Columbia, is that there's nothing inherent, as you say, in the Christian faith that would require a Christian to forgo vaccination. And the Christian faith has a lot to say about conscience. And I myself, in addition to being a lawyer and aspiring legal scholar, am a Christian. Conscience is important. Professor Bird and I would never want someone to be forced to get vaccinated against their conscience. But the issue here is that the Christian faith itself is, for the most part, silent on these sorts of issues. And whether or not specifically someone should get or not get the vaccine, Christians are free to choose either of those. So to suggest that there's something inherently Christian about opposing it is in that sense incorrect, because many Christians, in fact, I would hazard that most have in fact gotten the vaccine.
So just briefly, Chris, if it's not inherent, where is it coming from within these communities?
Well, certainly our convictions and our beliefs are come from a lot of different sources. And in a lot of ways, they are all of our beliefs in one sense or another are religious, and we adhere to those beliefs with a religious fervor. But in this case, you see some of these beliefs that are, these individuals would have beliefs that come from the Christian faith, and then they have these other beliefs that have come from somewhere else. It may come from a political ideology. It may come, as we've discussed already, from misinformation, from fears for their safety. And I do want to be sympathetic to people who are scared and the vaccine hesitant out there. We need to meet them with grace, and we need to counteract misinformation with information, because we care about what is true. But in this case, we're seeing a complex mix of different convictions and belief, a little bit here and a little bit there.
Beautifully put, Chris. Now, Mark, I want to turn to you about the future of freedom of expression in this country. I mean, this case certainly makes me concerned about freedom of expression. A recent decision from the Supreme Court on free expression and comedy was 5-4, with 4 justices who would have really changed what freedom of expression means in this country. What do you think the trend is on this particular charter right?
Well, to be honest, Christine, I think freedom of expression is it ebbs and flows. There have always been attacks on freedom of expression. I think the challenge of the modern day is not that the attacks or the criticisms of free expression are greater. It's just that there are new challenges. Social media has really democratized expression, and so it's given lots of opportunities for people to say certain things and to have things said back at them. And some people don't like that cut and thrust. But in general, I would say at the legal level, the Ward decision that you mentioned, the comedy decision, it was a split decision, but it was very clear that freedom of expression in this country is important, and that there is no right to be outraged.
Thank you both so much for joining me for this. It's an important conversation. We've heard today about the cases of 3 men who were sanctioned for violating a court order. There's nothing new about facing punishment for violating a court order, and it is very important for our courts to enforce the rule of law. But in this case, the punishment included a requirement that the defendant say specific things that, while true, are things he does not believe. This, in my view, is a bridge too far. And while the conduct of these men may be extreme and worthy of punishment, the punishment must be appropriate. But what do you think? Was this case too far, or was this a good way for the courts to deal with ungovernable defendants? You be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.